Rule 130 on the rules on evidence. Let us distinguish between the old rules to the new rules on evidence. As what we have observed, there are a lot of insertions. Hello mga kakognizans, welcome back to my channel. For today's video, I will discuss the difference between the old rules on evidence to the new rules on evidence, or the 2020 amendments on the rules on evidence. Now, before we proceed to the distinction or any insertion from the old to the new rules, I will define first of what is evidence is all about. An evidence, as defined under Rule 128 of the rules on evidence, it is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. But I will not elaborate on that definition because our main topic is all about the amendments of the old rules on evidence. So let us proceed to Rule 128 of the rules on evidence. As what you can observe, I directly presented Section 3 of the Rule 128 because there was an amendment from the old rule to the new rules on evidence. So under the old rule, Section 3, admissibility of evidence. Evidence is admissible when it is relevant to the issue and it is not excluded by the law of these rules. Under the new rules on evidence, evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or these rules. So this section, admissibility of evidence, I consider this as the heart of the rules on evidence. Because when we talk of admissibility of evidence, we should consider the relevancy and the competency of evidence in order for the evidence to be admitted or to be admissible in court. It is relevant when such evidence has relation to the fact in issue to prove the existence or non-existence thereof. And it is considered as a competent evidence if it is not excluded by the Constitution, the law, or these rules. Now, the insertion of the new rules is the word Constitution. Under the old rules, there was no Constitution that exclude the presentation or the admissibility of evidence. It is only the law of these rules. But now, under the amended or the 2020 amended rules on evidence, the word Constitution was inserted as part in the exclusion of the admissibility of evidence. So let us have an example that excludes on the Constitution. See, for example, on the right against unreasonable search and seizures. So when someone was being arrested, it's because of the property that was searched on his possession without a virtue of a search warrant. Remember, without a virtue of a search warrant, and does not fall on the exceptions that to arrest a person without a search warrant or to search a property without a search warrant is valid. Even without a search warrant, as long as you apply the exceptions under those jurisprudential that I have been discussed on the topics on search warrant versus warrant of arrest. Now, kung gidakop na siya nga walay nakuhaan siya nga walay search warrant, then that evidence acquired that person is considered inadmissible as evidence. Why? So, see for example, nakuhaan siya og illegal drugs, but nakuha siya nga walay search warrant and wala sad na fall on the exceptions as what I have discussed on the previous topic. So, relevant ba to the issue? Yes, that is relevant to the issue. Nga naman, nakuha ang illegal drugs, ang gi-file is illegal drugs. Of course, that is relevant to the issue. Now, the second question, is that competent? The answer is no. Why? That is excluded by the Constitution. Why? Because wala kay search warrant. As a general rule, there must be a search warrant para makasearch ka sa property or sa lugar, designated place o sa katao. Therefore, that is inadmissible as evidence in court. Another example, in the case of a person under custodial investigation, it is also provided under the Constitution. Now, si A, being the suspect, is under the custody of the police officer. Now, ning-ingon siya nga, Sir, Mr. Officer, ako ang nagpatay. Naigitawag ito nga confession of guilt. Ako'y nagpatay. Now, ang question, ang katuba iya nga testimony nga niingon siya, ako'y nagpatay, makonsidered ba nimo siya as admissible evidence in court? So, we should examine first. So, is that testimony or confession of a person relevant to the fucking issue? Yes, that is relevant to the fucking issue. Why? Because his confession is all about on the crime that he was committed. Therefore, relevant siya. Now, the second question, is that testimony competent? Kung yung competent not excluded by the Constitution? The answer is no. That is excluded by the Constitution or that is incompetent. Why? Because before a person or a suspect nga makonsidered nimo ang iyang confession of guilt is admitted or admissible as evidence, kinahanglan siya i-reduce into writing and must be done in the presence of the counsel. Based on the facts, wala ko niingon nga gi-istorya siya or gi-reduce niya into writing in the presence of the counsel or of his counsel, I mean. Pero wala man. Dito raman sa atubangan ni police officer. Therefore, ang ihang confession is relevant to the fucking issue, but dili siya competent. Dili siya matawag na to as competent to be admitted as evidence. Therefore, dili na sad siya admissible as evidence. Another thing also, on the case of right to self-incrimination, it is also provided under the Constitution. Now, naigitawag nga violation of your right to privacy. It's because of your confession sa imuhang right against self-incrimination. Karon, magamit ba to siya ni mga ebidensya? Let us examine first whether it is relevant and whether it is competent. Now, ang iyang giistorya or nakuha based on the violation of the right to privacy, relevant ba? Yes, that is relevant to the fucking issue. Now, second question, that is competent ba? No, that is not competent. It is incompetent or it is excluded by the Constitution on the violation of his right to privacy. So, another example. So, si A is naka-overheard siya or naka-use siya naka-wiretap siya of any confidential information during sa pagpanghitabo nga napatay ang biktima. Naka-record siya sa tanan nga mga palag-istorya, conversation, now gi-present as evidence in court. Now, is that wiretap nga mga conversation nga nakuha ni witness be admitted as evidence in court? So, let us examine again. Is that acquired evidence through wiretap and overheard the conversation of those persons that were being involved in the commission of the crime relevant to the fucking issue? Yes, that is relevant to the fucking issue. However, it is not admitted as evidence because it is excluded by the Constitution or by the law. Under Republic Act 4200, that any evidence acquired nga na overheard nimo in the conversation without the consent of the parties, that is inadmissible as evidence in court because that is not competent to be admitted as evidence in court. So that is a prohibition under Republic Act 4200. So muna sa law na to. Again, what was being changed or what was being inserted under the new rules and evidence under Section 3 of the Rule 128 is the word Constitution. So let us proceed under Rule 129. So Rule 129, judicial notice when mandatory. When we talk of judicial notice, when it is not to be proved. Meaning to say, there is no need for the evidence to be provided. Why? Because the court can take judicial notice. So, kung inyo ang makita, ang nausab lang aning Section 1 under Rule 129 is the word national government. So, sa old rule, there was no insertion of the word national government, but on the new rules on evidence, there was already an insertion of national government. And under the there is one case decided by the court where there was an issue about an ordinance, whether or not the court or the local courts can take judicial notice on that ordinance. So, based on this amendment, by the insertion of the word national government, the local courts or any local courts having jurisdiction on the violations of the ordinance cannot take judicial notice unless it is provided under their charter. So, let us proceed. The same rule under Section 3 or judicial notice when hearing is necessary. So, as what you can observe, from the old rule to the new rule, there was an insertion of the word during pre-trial on the first paragraph. So, meaning during pre-trial, on the old rule, during trial lang pwede makatake og judicial notice on any matter. Remember, on any matter ang giingon sa first paragraph. During pre-trial and during trial. And also, there was a replacement of the word on its own initiative or on request of a party into motu proprio or upon motion to take judicial notice again on any matters. So let us proceed to paragraph 2. On paragraph 2, ang giusab diha is the same true with the first paragraph on initiative or on request of a party that was replaced on motu proprio or upon motion. But here in second paragraph, and also the before conviction and after trial, and of course they have the same effect. But the most important thing here under paragraph 2 is that such taking of judicial notice must be on the matter which is decisive of the material issue in the case. Unlike on the first paragraph, on any matter, the court can take judicial notice. But on the second paragraph, it is only on the decisive, on the material issue on the case. So, let us proceed. Section 4 of the same rule, Rule 129, judicial admissions. What was being replaced is the word that no such admission was made and changed into that the imputed admission was not in fact made. So, for that matter, under this section, the Section 4 or judicial admissions, there was a so-called specific explanation on that matter. Say for example, kay ning file ka og answer, then wala nimo gi-impute dito sa imong answer, although ning tubag ka imong gi-answeran, but there was an imputed admission on the fact and issue. So wala kaning kan, or that imputed admission was not in fact made. So naay answer but wala kaning ingon nga imong gi-admit ang fact and issue. Now let us proceed to Rule 130. What was provided under the Rule 130 or Section 2 is on the documentary evidence. So under the old rule, documentary evidence is consist only of writings, materials containing letters, words, numbers, figures, symbols, or other modes of written expression offered as proof of their contents. However, under the new rules, there was a lot of insertion. So, nanadihang gitawag na ito nga recordings, photographs, and any materials containing letters, words, and sounds. So, what are those considered photographs? Photographs include pictures, drawings, stored images, x-ray, films, motion pictures, or videos. So meaning to say, ang imuhang basihan karon is the new rules na naidaghan nga mga napuno to be considered as a documentary evidence. Kanang recordings nimo, photographs, appeal na siya. But ikinahanglan sa ninyo nga isulod sa una nga to be considered as a documentary evidence, it must be offered as to the proof of their contents. Otherwise, dili na sa nimo pwede gamiton. Say for example, kung ang recorder o ang kamera gilabay nimo dayon na igo ang usa ka tawo, na igo sa dayon na namatay tungod sa internal hemorrhage or imong gipukpok sa laing tao. Now, imong i-offered siya. Mingon ka nga kanang imong i-offered as evidence, as documentary evidence. No, nga naman wala ka nag-present as documentary evidence. Why? Because the fact in issue is not on the content of the camera itself, is not on the content of the recorder, but on the physical itself nga mao na imong gigamit in the commission of the crime. That is why niingon ko nga mo yung documentary evidence ang imuhang gustong i-present diha is as to the proof of their content. Since dili man ang content ang imuhang gi-provide diha as evidence, ang iyahamang physical itself nga mao na gigamit nimo in the commission of the crime, then that is considered as an object evidence and not a documentary evidence. So, let us proceed. So, Rule 130, Section 3, kung makita ninyo sa una, best evidence rule na siya. But for now, gitawag na nato siyang original document rule. So, again, kalimtin na ninyong best evidence rule. Nga naman, there was already an amendment of that old rules on evidence. Wala na si best evidence rule, kundi igamit na nato is original document rule. Question, is there a difference with regards to the application of that rule? The answer is no. They have different, there was no different in terms of application. Parehas ra, but there are some insertions to be considered. So, when subject of inquiry is the contents of the document, no evidence shall be admissible other than the original. So, kung ang content gani na mismo ang gi-question, therefore wala kay laing ebidensya kundi ang original document itself. However, there are some exceptions. Kung makita nyo sa old rule, there are only 4 exceptions. However, under the new rules on evidence, there are 5 exceptions. So, let us proceed to paragraph A. Kung makita niyo sa paragraph A, sa paragraph A is wala siya nausab. Kung ma-lost or destroyed without bad faith, then pwede na dili original document ang imong i-present as evidence in court. Then paragraph B, so original is in custody or under the control of the party, is offered nga fails to produce it after reasonable notice. But there was an insertion under the new rules. So, let us read the insertion. Or the original cannot be obtained by local judicial process or procedures. Meaning to say, na siya gigamit ng judicial process. Let us say, for example, nag-issue og subpoena ducisticum ang court in order to produce such original document, but wala gihapon siya na-produce. Therefore, pwede na ang copy or any authentic nga copy ana niya or any recital as long as the existence and the execution of such document nga ma-provide is true and correct. Matawag nato siya nga somewhat like as a secondary evidence, but the secondary evidence on the preceding section does not refer to this paragraph B. However, as long as you can provide the existence, the execution, and the authenticity of such document in the absence of the original document, then it can be considered or it can be acceptable as evidence in court. Now, let us proceed to paragraph C. On the paragraph C, so wala siya na-change. Nag-story na gihapon siya about numerous accounts or voluminous nga makakos o great loss of time sa court, then pwede ma-receive ang mga summary. Pwede ma-receive ang summary kay lain sa kayo ang usa ka libraryhan nga mga ebidensya imong daduhon dito sa korte kay para ipa-examine nimo usa-usa. So that is why the summary is considered as an exception to the original document when the question or the subject of inquiry is the content thereof. Now, let us proceed to letter D. Ang paragraph D. Paragraph D is walay na usab from the old rule to the new rule. Of course, ang original is a public record and is recorded in the public office. Now, arita sa paragraph E. Paragraph E, dili na nimo makita sa old rule. Ari na nato makita sa gitawag nato nga new rules on evidence. And what is that? When the original is not closely related to a controlling issue. So, unsa may pasabot ana niya? So, say for example, ang original lang yung ipasabot na to ani is dili siya maoy main topic or main issue. Diba? It's not closely related to the controlling issue. So, let us just say for example, on the case of collateral matters. Diba? Collateral matters as a general rule is not accepted as evidence or cannot be admitted as evidence. However, when such collateral matters tend to prove the improbability or probability of the fucking issue, then it may be considered as an evidence or it may be admitted as an evidence. Now, let us just focus on the not closely related to a controlling issue. See for example, a deed of sale. A deed of sale was being asked to be presented as evidence. para ma-assure nimo nga there was a perfection of the contract. Therefore, i-provide nimo ang document, ang deed of sale. And the question is not on the content of the documentary, not on the content of the deed of sale, but the question is whether or not naabay na exist nga deed of sale. So therefore, ari na to isulod nga when the original is not closely related to the controlling issue. Why? Dili siya closely related. Nga naman, dili kinahanglan ng original kay again, we are not asking, or the subject of inquiry is not the content thereof, but ang iyahang subject of inquiry is whether or not naabay nag-exist nga deed of sale. Therefore, maunay gipasabot diri sa paragraph E sa bag-o nga rules on evidence. Another thing also, in the case of kanang inyohang mga ticket sa pagsakay ninyo sa bus, pagsakay ninyo sa barko, or pagsakay ninyo sa eroplano, kung imo na siyang i-present nga tinud-anay nga nakabayad ka, that is an example nga when the original is not closely related to a controlling issue. However, when your question is on the terms and fines and conditions under that plane ticket or under that vessel ticket or under that any transportation nga gi-issue nga ticket, then di na sad pwede nimong gamiton na siya. Now, kaya nga naman, kaya ang imuhang issue is all about the content of the plane ticket and not any other controlling issue. Niingon lang ko ganiha nga masulod nato si paragraph A kung pananglitan ang imuhang issue is not the content thereof. Ha? But nagpamatuod lang nga nakapliti ka na akay plane ticket. So another example. See, for example, nakakos kag injury to another. Ang imuhang rason, it's because of the billboard. It's because of the billboard nga sige kag tanaw. Now, kinahanglan ba nga dad-o na dito sa court ng billboard ya tangtangon ipakita kay mo ni original? No. Pwede na dili kay nga naman we are not asking for the content of the billboard kung nabay nagbakini diha or unsa bay nakabutang diha, but ang imuhang gipasabot is the billboard itself and not the content of the billboard. Therefore, pwede na siya as an exception to the original document. So, I hope you understand and can distinguish the new amendments from the old rules on evidence. Now, let us proceed to original document, or what is the original document as provided under Rule 130, Section 4, from the old rule to the new rule on evidence. Now, under the old rule, there were only three definition to be considered as an original document. However, under the new rules on evidence, even though there are only three specifications of an original document, but there was an insertion of the word duplicate. So an original of a document is the document itself. Of course, may original is the document itself. Or any counterpart intended to have the same effect by a person executing or issuing it. Meaning to say, there was a duplication to be considered as an original, produced by the same impression as the original, as to from the same metrics or by miniatures or by mechanical or electronic recording or by chemical reproduction or other equivalent, to be considered as a duplicate or a counterpart to the original. So as an example for that is the photocopy. The photocopy of the original is considered as a counterpart and considered as an original document. Now, when we talk of photograph, a photograph includes the negative, any print therefrom. So, meaning to say, kung ang imuhang pictures diha or photograph na kay negative, katong mga karaan, kung sa Kodak pa ka magpa-picture na ay negative, so katong negative nimo is considered to siya as an original document. Original document as proof of their content. Now, if the data is stored in computer or similar device or any printout or other output readable by sight or other means, that is considered as original document. Say for example, ang imuhang mga pictures is nakasave sa imong cellphone, nakastore sa imong cellphone, imong gipaprinta. That printout is considered as an original document. Pananglitan nakuha imong cellphone, gipaprinta naglain, gipaprinta imong cellphone, imong pictures sa imong cellphone. That printout is considered as an original document. Understand? Now, ang giingon is niya na siya should to reflect the data accurately. What if gi-edit na diha, gi-edit na diha mong naong, gibutangan na nagsungay or gibutangan na ka diha og buhok bisag upaw ka. Then dili na siya ma-considered as an original document. Why? Because it is clearly provided under the new rules and evidence that is should to reflect the data accurately. So accurate pa ba dahil na? Nga dili naman. Therefore, di na siya ma-consider mo as an original document. Now, let us proceed to the duplicate that I have mentioned earlier. Duplicate includes photocopy as long as of the same impression siya, the same metrics as to the original. But that is subject to certain inquiry. Ha? Pwede na nimong ma-question nga klase nga ebidensya. Admissible to some extent as an original unless a genuine question is raised as to the authenticity of the original. So, there was a genuine question nga imong gipangutana tungod kay nagduda ka sa iyahang originality of that certain documentary nga or documentary evidence nga gi-provide siya as evidence in court. Second, in the circumstances nga which is unjust or unequitable or to admit duplicate in lieu of the original. So there are two instances nga pwede nimo i-question si photocopy ha or si duplicate nga dili nimo siya ipa-consider as original. But as a general rule, ang photocopy or a duplicate is considered as a counterpart of the original under the new rules on evidence. So, Rule 130. Under the old provisions, there was no or under the old rule, there was no provision about summaries. But on the new rules on evidence, there was already an insertion of Section 7 which provides the definition or the explanation of summaries. Before, kung mingon tag summary is naa lang siya sa exceptions nga akong gimang-mention ganiha about sa exceptions from the original document. Sa new rules is naa na gid siya ihang kaugalingon nga rule which is provided under Section 7 that a summary is when the contents of document records, photographs, or numerous accounts are voluminous and cannot be examined the court without great loss of time, and the facts so to be established is only the general result of the content of such evidence may be presented in the form of chart, summary, or calculation. So it is very clear nga pag-inom pa na ako ganiha, dili kinahanglan nga usa ka libraryhan, usa ka budigahan nga mga dokumento ang imuhang i-present sa court kung nag-considered siya as voluminous or numerous siya nga accounts nga mokuha na siya og great loss of time. So pwede na ang summary, pwede na ang chart or any calculation imong i-present dito sa court, provided that you conducted a thorough examination and scrutinized in every details para sa nga dili na siya magwaw mali ang imuhang mga calculation or summary. Dili kinahanglan ang kinatibuk-an nga ang tanan, kung dili pwede lang ang kinatibuk-an nga imong i-present as evidence in court. So, I think that was the whole amendments under Rule 128, Rule 129, and 130 on the revised rules on evidence. So, on the next video, we will discuss on another amendments under the rules on evidence as to the parole evidence rule or any other provisions that were amended or that was amended under the 2020 amended rules in evidence. I hope you understand on the distinction or any insertion under the rules on new rules on evidence, because it really matters when you take your board exam. There are more than 20 provisions that was being amended under the new rules on evidence, and this amendment might be included in your board exam. So I hope you will subscribe and hit the notification bell for more updates, and also you will be updated for the part 2 of this discussion. Thank you and God bless.